Right, and another story regarding competition policy for companies operating here in South Africa. In President Ramaphosa's State of the Nation address, he announced that he will prioritize the signing of the Competition Amendment Bill into law. This bill has been created primarily towards transforming the economy by helping small to medium and black-owned businesses penetrate the market. But how will this bill change the South African business landscape and, more importantly, the merger and acquisition space? For more on this, I am joined by Lara Granville, a director at Cliff Decker Hofmeyr. Lara, thanks so much for your time. All right, so exactly what is this bill intent on doing?
So the bill is now an act because President Ramaphosa signed it yesterday. The intention of it is, as you said, we've identified certain problems in the South African economy, high levels of concentration, a lack of transformation, so primarily large businesses in the hands of, in white hands, and a certain lack of dynamism in the South African economy, and that there's not a lot of entry and exit. It's not that easy to enter and exit, which undermines competition. And so those are the problems that the changes to the Act are designed to address.
I mean, even the IMF chief, when she visited South Africa, she did speak about the problem of the monopolies here in certainly hindering the kind of economic growth that we're looking for. But how does this move the needle, particularly for small businesses?
Well, primarily I think it's about incentivizing big businesses or telling them that there's some disadvantages if they act in a way that closes off opportunities for smaller businesses and black-owned businesses. So it's about creating and driving business behavior to know that there are consequences if barriers to entry are heightened or conduct is undertaken which excludes other players or forecloses access to markets.
Sure. And I see that you are a bit concerned about the impact that this could have on mergers and acquisitions going forward. Why so?
I'm not sure that I am. I think that merger and acquisition activity will be driven by other financial and economic concerns. So if it's a good investment, it will be pursued. We already have the regulatory hurdles of the competition enforcement process in place. Sure. And I don't think that this significantly increases it. One area that raises concerns is that there's a provision designed to provide the government with a veto in the case of national security impacts. And I think that might, depending on how it plays out and how widely it's applied, might cause some delays and uncertainty. But other than that, when it comes to the real policy drive of the new Act, when it comes to the additional provisions in the Act, I'm not sure that it'll have a negative impact on M&A activity at all.
Right, but I see it raises the potential fine that companies, big companies particularly, who are found not behaving well, from 10% of their annual revenue to around 25% of their annual revenue?
Yes, so that would be in the case where there's a repeat offence. Right. So again, when it comes to the risks of prohibited practice conduct, the maximum penalty is 10% of turnover, which is already a very high fine, but that is calculated in any particular instance based on the context of the contravention and so on. So that has been multiplied significantly in the case of a repeat offence. There's also a provision providing for a potential higher fine if the holding company or controlling company of the infringing company knew about the conduct. So there is certainly scope for increased fines here.
Sure. Well, I suppose, as you say, it's now an act since it was signed officially yesterday. It remains to be seen whether it is successful in increasing competition into South Africa's economy. That was Lara Granville, a director at Cliff Decker Hofmeyr. Let's go to another shorter break. Be with us in just a minute.